Donald Trump delivered a statement on Thursday. He said he will appeal judges' ruling that he is not immune from being charged with federal crimes for his role as a former president or his efforts to overturn outcome of 2020 election. Because of Constitution's impeachment rules, notification is a minor procedural step, but it sets in motion one potentially most important parts of the legal saga: Trump, who became first former president to be charged with crimes. How and when U.S. Court of Appeals for District of Columbia Circuit and Supreme Court hear appeal could have a major impact on whether Trump, who is running for president again, will be tried before voters go to polls in 2024 or not. Trump's legal team says charges that he conspired to thwart Joe Biden's 2020 victory should be dismissed for two reasons. First, his lawyers claim he has presidential immunity. Second, they argue that accusing Trump trying to obstruct election results violates legal principle of double jeopardy because Trump has already been acquitted congressional impeachment for his conduct that led to official electoral tally marred by riots on January 6, 2021. University votes. U.S. District Judge Tanya S. Chutkan's 48-page opinion last week included those allegations, along with a separate objection that said the indictment should never have been filed because it improperly sought to criminalize Trump's constitutionally protected speech and advocacy rights as a political candidate. Denied. Since a grand jury voted to bring criminal charges this summer, prosecutors have sought to try Trump as quickly as possible. Trump's lawyers insisted their client needed and deserved more time, both as a defendant reviewing evidence and as a former president trying to regain the White House. Appellate courts consider very few legal issues before a criminal case goes to trial and a decision is reached. But issues of immunity and double jeopardy are generally exceptions. Because if the defendant is correct that he is not indictable, courts have held that the defendant should not be forced to stand trial at all. And because the Supreme Court has never addressed some of the legal questions in Trump's claims, specifically whether a president is immune from indictment and criminal prosecution for actions taken while in office, or even after he leaves office. Many lawyers say they believe it. The courts will have to grapple with these aspects of the Trump case. The question, according to legal experts, is how long the higher courts will consider this question. Trump is scheduled to go on trial in Washington, D.C., starting March 4, and potential jurors in the nation's capital have received notices that they are being considered for a 3-month trial to begin on that date. This will be the first of 4 criminal trials Trump could face, including federal involving classified documents South Florida, a state-level election obstruction case in Georgia, and state-level business New York.